A very good evening, everyone. So it's been a long since we had a video updated in our channel, Lord Denning's Law House. So it's been 2-3 months almost. So I would like to tell you one thing, that finally I am an advocate and I've enrolled myself in the Bar Council of Tamil Nadu and Puducherry. So what's so special today is that we are gonna see a murder case, which is rarest of the rare case. So this is all about the murderer who is claiming his right for the furlong. So those people who have heard about furlong, it's fine. So others who don't know, it is a time period, a break time for the prisoner who is in the jail and has been serving in the jail as a prisoner, and he hadn't got his right. So let's get into the case and get to see through what it is all about. So this is a case about Atbir versus the state of NCT of Delhi, and in this case the prisoner who committed a murder is being held liable and he is sentenced to death, and that got changed later on. So we'll just get to go through the dates and events which I made for your better understanding. On 8th of December 1996, an FAR number 24 of 1996 was made, and on 15th 11 2021 the furlong for which he had applied got rejected. So that's a long period. So he has almost served 26 years in the prison, and now he has claimed for the rights of furlong. So parole is a time wherein a person is released for a time being, and that time being where he is released is not actually got into account and it's not calculated. So what's the difference between parole and furlong? That's kind of a typical thing, and it's something we need to be making an analysis with, and I'll separately make a video on that. So furlong is the right. Just get to have this in your mind. It's a break time for a long serving prisoner. So this person, Atbir, he committed a murder, and that murder was done by him when he was 25 or something. So he almost served for 26 years, and now he needed a break. So this definition of furlong has been given detailed. So as we just go through the dates and events, we'll get to connect with it. So 10/9/2004 is the date on which sentence to death was awarded to him, and the order was passed on 27/9/2004, and his appeal from the lower court was made on 13/1/2006, and the appeal got dismissed. And again an appeal number 870 bar A and 877, it was made on 9/8/2010, and that was dismissed too, and he made a review petition and a curative petition which got dismissed too, and the curative petitions plea was not also considered. So in this, the review petition number is 518 of 2020. So considering all these facts, he was sentenced to death, and he made an appeal, and the appeal was dismissed. He made a curative petition that was dismissed, and later he invoked article 72, which says president has a right to consider a prisoner's penalty and the death sentence. So exactly, if you want me to read the article, I may do so. So article 72 deals with the pardoning powers of the President of India. When the President of India takes an action over the case of punishment or sentence of any person convicted for an offence, it takes the form of for his pardoning powers. So here President made a very specific word, and he doesn't actually take the decision on his own. So the ministry supporting it will be giving some ideas. So as in, like, if a person is applying for a furlough, he needs to fulfill the demands or the criteria for which he is applying for the furlough. Delhi Prison Rules 2018 and Rule 1223, the eligibility requirement to obtain a furlough of 3 annual good conduct reports and not 3 annual good conduct remissions. So it says that he needs to have a report of 3 years of good conduct through which he'll be rewarded and he'll be given with the furlong. But when the president stated, when he gave this decision about his death sentence, he changed the death sentence from that to life imprisonment, and he has to serve in the prison till his natural life. So till he dies, he has to be in the prison. So where does this problem arises? There is a difference between remission and also furlough, and good report of remission and good report of good annual report. So there is a difference. So remission, uh, furlong, parole, release, there are minute differences which we need to look in very well. But it was argued in the court by the uh, counsel for the petitioner, stating that he cannot be denied with this right of having a furlong because it is more like a violation of his fundamental right. So it actually clashes with the rule. So according to the rule of Delhi prisons, it is just that he had to have a good report, and good report of the conduct and not good report of the remission. So there is a difference, and the interpretation differs with every person, right? So that's what. So I'll read out the concerned rule from the Delhi prison rules, and I'll just let you know. Chapter X1X of Delhi prison rules 2018 deals with the matter concerning parole and furlong. So it is explained here. Parole and furlong to inmates are progressive measure of correctional services. The release of prisoner on parole not only saves him from the evils of incarceration, but also enables him to maintain social relations with his family and community. It also helps him to maintain and develop a sense of self-confidence. Continued contacts with the family and the community sustain him to have a hope of life. The release of prisoner on furlong motivates him to maintain good conduct and remain disciplined in the prison. Parole means temporary release of prisoner for short period so that he may maintain social relations with his family and the community in order to fulfill his familial and social obligations and responsibilities. Furlong means release of prisoner for a short period of time after a gap of certain qualified number of years of incarceration by way of motivation for maintaining good conduct and remain disciplinary in the prison. Three important things is that good conduct in the prison should have earned rewards in last 3 annual good conduct report and continue to maintain good conduct. The prisoner should not be a habitual offender. The prisoner should be a citizen of India. So these are some 3 conditions for which needs to be satisfied. So I'll read out the exact words which is mentioned by the president. We'll get to understand why the defendant side feels that it is violative of the president's order. So we'll just get to go through it. I have pursued the mercy petition under Article 72 of Constitution submitted by the condemned prisoner Atbir, son of Sri Jashwant Singh, and have also studied the judgment of Honorable Supreme Court and comments and recommendations of the Ministry of Home Affairs. After considering all the facts of the case, I agree with the recommendations made by the Home Ministry to modify sentence of death of the condemned prisoner Atbir, son of Sri Jashwant Singh, to one of the life imprisonment. However, the prisoner shall remain in prison for whole of the remainder of his natural life without parole, and there shall be no remission of the term of imprisonment. So here he has mentioned something about the remission and not about furlong. So there were few cases which was mentioned by both the defendant and the petitioner counsels. So I'll just get to mention those case names. Just get to go through it, and you can have the two-sided way of arguments. So Chandrakant Jha versus State of NCT of Delhi, and Union of India versus V. Srihari and others, 2016 7 SEC 1. So I'll get to share the PDF which I got to go through, and you'll have a better insight of this one. Why it is called the rarest of rare cases? Because he stabbed his own family, his stepbrother, his stepmother, and his sister, like almost 36 times or something. So I'll have to go through the original judgment before I come to this one. So furlong can be awarded to a prisoner who has a good conduct, and the 3-year report is for the good conduct and not for 3-year good conduct for the remission. So remission is what president has spoke about, and he hasn't mentioned anything about furlong. So furlong is different from parole. So we have to understand what parole is and what furlong is. Only then we'll have to come to a conclusion. This is one best appeal which we can mention here. And while mentioning this judgment, this order, the Supreme Court has mentioned something like furlong should be differentiated and read properly from parole and other stuffs. So this is what it is mentioned in the last line. For what has been observed, discussed, and held herein above, this appeal succeeds and is allowed. The impugned order dated 2/8/21 as passed by High Court of Delhi, and the order dated 21/10/2019 as passed by the Director General of Prisons Headquarters, Tihar, Janakipur, New Delhi, are set aside, and the case of the appellant for grant of furlough is restored for reconsideration of the said Director General of Prisons. For that matter, a fresh report may be requested from the jail authorities, and the matter may be proceeded in accordance with law. We would expect the Director General of Prisons to take a decision in the matter expeditiously, preferably within 2 months from the date. So this is one good case where, good appeal case where you could get to know how interpretation of statutes can be invoked and how we could make a better argument in the courtroom. So that's it, people. So this is a fresh start. So if there is any lag, please do forgive me, and please do like, share, and subscribe my channel, Lord Denning's Law House. So let's get to meet in another video. Thank you.